Hello to everyone joining us virtually. Welcome to day 2 of BVI Arbitration Week. The topic for this morning's session is third-party funding in the Caribbean. Our speakers in no particular order are Dana MacGrath. Dana is an independent arbitrator with 2 decades experience in international dispute resolution. Her unique mix of experience includes serving as an arbitrator, arbitration practitioner, and in-house counsel in arbitration finance. Most recently, Dana served as legal counsel and investment manager at Omni Bridgeway, a leading global litigation and arbitration finance company. In this role, she led arbitration investments out of the United States while also serving as an independent arbitration practitioner. Dana was a partner in the International Arbitration Group at Sidley Austin, LLP. Previously, she served as an international arbitration practitioner and arbitrator at Allen and Overy. She started her legal career in the litigation department at Sullivan and Cromwell. Dana's high-stakes international arbitration matters have involved a variety of businesses and industries, amongst them oil and gas, and LNG, energy, construction, finance, telecommunications, intellectual property, construction, sale of goods, and international investments. Yasmin Mohammad is the head of international arbitration and head of the Paris office at Banin Capital, a market leader in legal financing. Her experience in the arbitration funding market is unrivaled and spans across single case funding, award monetization, enforcement funding, and a range of different bespoke portfolio arrangements. Yasmin regularly speaks at industry conferences and contributes to leading publications and journals. So Yasmin is our funder on the panel. Next up is Peter Ferrer, is co-head.
Good morning, everybody.
Co-head, morning, Peter, of Harney's Global Litigation, Insolvency and Restructuring team. Peter acts on behalf of institutions, companies, entities, and high net worth individuals. His experience includes shareholder actions, fraud claims, hedge fund disputes, insolvency and restructuring matters. He has extensive experience in enforcement proceedings, including tracing actions in multiple jurisdictions. He is an experienced trial advocate who regularly appears in the British Virgin Islands Commercial Court Division, Eastern Caribbean Supreme Court Court of Appeal, and in international arbitration. We are also expecting Martin Kenney. He's a bit late, but he is one of the world's leading asset recovery lawyers, specializing in multi-jurisdictional economic crime and international serious fraud. He has acted for international banks, insurance companies, individual investors, and other private and governmental institutions. And I am Tameka Davis, your moderator. Funding the cost of resolving disputes has always been one of the key considerations for potential litigants or parties to an arbitration. And one of the important choices which a party needs to make is how to do so. Indeed, the ability or lack thereof to fund a dispute can be decisive to the choice whether to proceed with commencing an arbitration or court action or not. As the demand for flexible funding option grows, so do the opportunities to fund a dispute. Specialist funding providers and even law firms have sought to devise various ways to get in on the action. But as third-party funding has gained prominence, so has the scrutiny of these arrangements. In this session, we will not only examine the scope, limitations, and pitfalls of third-party funding arrangements, but we will examine the factors which drives a funder's decision to fund an arbitration or the enforcement of an arbitral award and an arbitrator's approach to these arrangements. So Yasmin, can I just start with you? The first question is, as a funder, what are the key questions you would like answered before funding an arbitration or an enforcement of an arbitral award?
Of course, hello, Tameka, and hello to my co-panelists. Good morning to the BVI. As we were preparing this panel, we discussed together the various aspects, whether jurisdictional to the specific jurisdiction or to the case itself, that we would review as funders in order to determine whether we would be interested to fund a dispute. So there are the aspects that concern the case itself. And the case itself, we would look at the general aspects that law firms would vet when reviewing a case, just to give a merits analysis to their client. Interestingly, maybe for some people, we start usually in reverse order, where law firms would start with jurisdiction, merits, quantum. We will start with enforcement, quantum, merits, jurisdiction. And we will get to those specific issues later on in the session, as I know. But one of the things that we don't think about so much now that funding has become more and more prevalent in many jurisdictions, and especially Anglo-Saxon jurisdictions, is whether funding is legal at all. As a lot of you will know, the notions of champerty and maintenance, Middle Eastern, well, notions from the Middle Ages, I was going to say Middle Eastern, Middle Ages, those notions have permeated through modern common law and remain sometimes an issue to funding. So one of the first questions we would ask is typically, is funding even legal in the jurisdiction where one would be seeking to enforce a funding agreement? And that's certainly one of the questions we would ask if we were to fund a dispute with a seat in the BVI, with a funding agreement, with a governing law that's set to be the BVI. That's certainly one of the first questions we would ask.
And Peter, I'm going to ask you to answer that question. In the BVI, is funding legal? And what sort of third-party arrangements would a BVI court consider to be enforceable or legal under BVI law?
Thanks, nice to meet you again. Thank you for the question, Yasmin. So in the BVI, third-party funding is still in its infancy. We don't have the same sort of regulations, acts, legal framework that you have either in the States or indeed in England and Wales. In the BVI, there has been previous experience in the insolvency context where there's always been third-party funding allowed. So the courts do have experience of looking at the funding arrangements and providing sanction, because typically a liquidator will go to the court to say, I've got this funder, there's no way I can bring this claim on the behalf of the estate unless I have this particular funder funding the litigation. Will you approve it? And in a recent case last year, a case Russell Crumpler against hang on a second, it was Russell Crumpler against Exential, I think that's how you pronounce his investments. It's easier just to remember Russell Crumpler and David Standish as the claimants. The court decided in that situation that there has already been an abolition in relation to champerty and maintenance from the criminal code, so it's not a criminal offence. When it was abolished, they didn't maintain the public policy exception, which had been an issue in England in relation to champerty and maintenance. And the court had no difficulty and said, in fact, it was indeed the public policy of the BVI to assist in having access to justice, because there's no other way in which the claimants and the creditors in that particular case could arrange funding to proceed with the case. So is it legal in the BVI? I'm going to stick my neck out and say, because of the way in which the Insolvency Act had been dealt with, then if there were a third party funding in another arrangement, then it would be. Obviously, we have to make a difference between litigation and arbitration. In the litigation context, if you're a legal practitioner, BVI legal practitioner, there is in fact in the Code of Conduct a provision where it said it is not improper for a lawyer to take a contingency or enter into a contingency arrangement, provided it is fair and reasonable, and then there are various factors which they set out. So so even in the legal context, I think on an enforcement action, if it's court action, then I think you would have that provision which you could safely rely on because it's in the code of conduct. In the arbitration scenario, I think we're going to come on to discuss how exactly that worked, but I would stick my neck out and say it's likely that if an application were made, the judge would find favor with it.
And funding is a pretty broad definition. Yasmin, is there any sort of jurisdictional uniqueness with the definition of funding that may inform whether you decide to fund a matter or not?
Yes, I mean, the definition of funding is actually one of the aspects of legal finance that has created the most literature. Funding, when it first became accepted and known amongst the legal profession, really dealt with the kind of examples that Peter was giving, which is typically insolvency procedures, David versus Goliath situations, situations in which there was an access to justice issue. But as we know, funding has greatly evolved to many different aspects, or many different forms of funding, I should say. There are now today some perfectly well-capitalized companies who are choosing funding as an accounting or financial means of financing their legal departments. And it's not an access to justice point to them. It's just smart financial thinking and planning. They'd rather use their own capital to run their business rather than to run litigations to go recuperate capital that they thought that they should have won until then. So the forms of funding have evolved. And it's interesting that Peter early on was mentioning that he thought that because of the code of conduct of lawyers allowed contingency fee arrangements, then there was reason to believe that a judge outside of the insolvency context would allow funding. And whereas third-party funding at its primal stage is a third party. So it's not a party to the dispute, not even the lawyers in the dispute, literally an entity completely outside of the dispute. And interestingly, in other jurisdictions, Asian jurisdictions in Singapore and Hong Kong, where contingency fee arrangements are not allowed, this confusion sometimes between third-party funding and contingency fee arrangements have led to a mistrust, a misconception around what funding really was. And it really took some time for those jurisdictions to sort through their definition, their accepted definition of funding, to exclude from that definition contingency fee arrangements. So in other words, lawyers partially or sometimes fully in the States funding themselves disputes, and in order to be comfortable with the notion of funding. So this conflation had to be clarified for funding to be formally legalized through the legislation in both Singapore and in Hong Kong. Now, as you will have seen, there are a number of definitions now, accepted jurisdictions of funding that are floating about. Many centers have gone to define, arbitration centers, have gone on to define funding in the context of the disclosure of the need for disclosure of the funding agreement. The UNCITRAL working group right now is doing the same thing. It's looking to define it. ICSID has sought to define funding. And then the question arises is insurance funding, is loans, so recourse investments, are those funding as well? Obviously the notions of lawyers. So it's interesting, I think, and it's important for each jurisdiction or legal order, at least, whether we're talking about jurisdiction or international arbitration per se, to have an agreed understanding of what we mean when we talk about third-party funding.
Yeah, because I think certainly in the BVI and certainly in my experience, there is a conflation between the concept of third-party funding and contingency fee arrangements. There isn't that intellectual distinction that is made. And certainly there is a confusion, and there isn't a sort of sanitization of third-party funding. It's just funding by a third party. Whereas we tend to think of it in the concept of atypical ways to fund a dispute. But Peter, is there an accepted definition of funding in the BVI?
Well, no. So it could cover anything. It could cover third-party funding, which, as Yasmin has said, is sometimes a very tax-efficient way for companies to organise their affairs, even if they have the cash in order to pursue a case. It could cover contingency, where there is a percentage element. It could be some sort of uplift, where the lawyers agree to do a particular case and then have an uplift. It's interesting that in Cayman, because obviously we're discussing the Caribbean jurisdiction, and this year in Cayman, the Private Funding of Legal Services Act came into force, and so that's put on a statutory basis and also seeks to define what the funding is. And in that particular case, there are various definitions in relation to what a success fee is, what percentages a party can take as a success fee, what uplift is allowed by lawyers. And the fact they refer to it as private funding, I think, would cover a wide variety of circumstances. And the BVI has yet to choose what particular route it's going to go down. The fact that in the Code of Conduct, they refer to contingency. I mean, in my mind, that's the most extreme form of a third party where they take part of the damages. And so the fact that where the lawyer himself is involved is allowed and permitted to take a percentage seems to me to be a far more extreme version than a third party funder, where you have somebody coming in who on a commercial basis says, we will extend credit for this amount on these conditions and we expect this amount of return for our money.
So it seems to me that apart from the fact that funding is defined by the jurisdiction, it is going to be an important consideration for a funder as to what that actual definition is. But in practical terms, moving beyond sort of these general topics, what would be included in a funding arrangement, Yasmin, in terms of what will it cover in practical terms?
So traditionally, a funder would be asked to fund the various costs of a dispute and the various aspects of the cost of the dispute. Those include several things, or can include several things. They can include the lawyer's fees, whether deferred or not deferred, tribunal costs, fees, center costs, disbursements, general disbursements, like hearing costs, translation costs, all the various different costs that you can think of that can compose the overall budget that a client would normally need to expend in the context of their dispute. All of those things can be included in the amount that a funder invests in disputes. On the other side of the spectrum, there's another way for a funder to calculate their investment, which has nothing to do with the actual costs of that dispute, but a funder could propose a certain amount of capital to a client based on the upside that it's looking to make in a dispute. So on a contingent view of that outside, the funder can say, well, listen, let me take very big numbers just to illustrate my point. If a dispute is, say, worth, in terms of damages, but solid damages, $100 million, one could say to a client, here's 20 million upfront. You can use this money as you see fit. You undertake to us to continue to run your litigation or your arbitration or arbitrations as well as you have to date with this money as well, but the rest you can use to run your own business. So a real, private equity type investment, and the client could do that. So obviously funders don't do that with every client. So it would take a very specific type of client, large companies, going concerns, a really known quantity, known entity for a funder to do that. But you have those two sides of the spectrum, one where you calculate the investment on the actual costs that a client would expend if the funder weren't making that investment, or a portion of the expected value of the damages if and when the case wins. And in between that, there's a whole spectrum of possibilities. Sometimes clients come to us and they're only looking to fund, say, the the cost of their lawyers. They have some funds, and so they're paying for their tribunal fees or other costs, but they just need for us to fund part of their costs and disbursements, and we can do that too. So I think, just to make a long story short, third-party funding is, for the client, a financing tool. It depends what the client needs financing for. Is it really just the cost of litigation, or is it looking to draw on the value of that asset in order to raise capital? And third-party funding can do that too. And it could also be a client that has some funds that they're ready to spend on their litigation, but not all of it, and they want a portion of it paid. You're on mute, Tameka.
Yeah, that is interesting, because that's sort of going to the other extreme of essentially a lump sum payment of 20 million, do what you like. I certainly think that's a more, the less preferred way, because in my experience, sometimes where you have a tighter rein on third-party funding, it can make running a litigation or even an arbitration a bit challenging, because each step of the way you need to seek approval before you take a particular course, especially if it was not contemplated in a pre-agreed budget. But also included in that, no doubt, would be the arbitrator's fees. So Dana, as an arbitrator, is there a conflict between the concept of being paid by a third-party funder in practical terms and having to consider the validity or legality of a third-party agreement in the context of an arbitration?
Good morning from New York, and thank you to the organizers for including me. I'm sort of speaking mostly from my experience in litigation finance before going into full-time arbitrating, but I sort of have both perspectives. So with respect to the issue of arbitration fees by arbitrators or other arbitration costs associated with the proceeding separate from the lawyer's fees, I think the general issue from both the funder's perspective, I think, and an arbitrator's perspective in this respect is whether there is any connection or conflict relationship between the funder and the arbitrator. In the same way you would look to see if there was a relationship or connection between any of the parties or counsel in the proceeding and the arbitral tribunal. And so in that respect, it's, I think, very useful for arbitrators to learn early on whether the case is being funded, and if so, by whom. And some of the arbitration rules of institutions have expressly now stated the arbitrator may ask about that, or the parties are encouraged to disclose that. But I think under any set of rules that is a topic that can be raised and addressed by the parties and the tribunal. And as an arbitrator, you know, one of the main goals you have is to render an enforceable award, and obviously conflicts of interest are a significant obstacle to that. So you would want to find out as early as possible whether there's any entity that has an interest in the arbitral proceeding outcome. And if so, to have the identity of that party or that interested entity disclosed so as to ensure that there is no relationship or conflict with the arbitral tribunal members. And in my experience, that's been the extent of the disclosure. I think, you know, there are case-specific situations that may warrant more discussion of the nature of the funding, but from a conflicts of interest purpose, it's really whether there is funding and the identity of the funder.
And is it the panel, Dana, that will ask this question of the parties, or do you expect, or is there an expectation of a voluntary disclosure of the existence of this third-party agreement?
I think it differs depending on the rules under which you are arbitrating, but the panel, I believe, under any set of rules has the discretion to ask about it, because they have the discretion to run the case as they see fit to ensure you know, an efficient and fair process and an enforceable award. Some rules that have been recently amended have sort of spelled this out more specifically and have had stated that the tribunal may ask or that the parties shall disclose. But I think that underlying that is the general concept that any party or entity that has an interest in the outcome of the arbitration should be surfaced in the earliest stage of the arbitration to avoid conflicts. So it depends on the rules and the place.
Thank you. We have a question, and I think, Peter, this is a question for you. And this question is from Calvin Hamilton. Shouldn't some guidance come from the Eastern Caribbean Supreme Court on the question of whether champerty is still a matter of public policy applicable in the Eastern countries, in the, the 9 territories of the Eastern Caribbean?
Hello, Calvin, Professor Hamilton. So I think in relation to that, there has been guidance last year in the form of the judgment from Jack. So in the case with Russell Crumpler, admittedly in the context of the Insolvency Act, there was an express view given by the judge that the public policy of champerty and maintenance is no longer, certainly in the BVI. I'm aware that in other member states of the Eastern Caribbean Supreme Court, so for example in St. Lucia, the similar code of conduct that we have in our Legal Practitioners Act, in fact, dates back to about 1997, where it was the code of conduct for all lawyers in the Eastern Caribbean, and that specifically actually stated that it was not improper for a lawyer to take in a contingency fee of up to 20%. So in the original version of the Code of Ethics, there was a specific amount given, which again I think would indicate that the issue of champerty and maintenance is not as great as perhaps the common law position would initially indicate. Hope that answers the question.
Thank you, Peter. I think it does. So moving beyond, so Yasmin, moving beyond sort of the definition of funding, the legality of the funding arrangement in the jurisdiction of the seat or enforcement, what other considerations would you consider to be relevant to the decision whether to fund a matter?
One of the most important considerations that we look at from the outset is, will we be in a position to enforce a favorable decision? And that needs to take a look at 2 very different aspects. The first is the validity of the arbitration at its own seat. So say, for instance, whether the arbitration that's being run in the BVI Arbitration Center with a seat in the BVI, would that arbitration sustain a challenge or a set-aside? That's one of the first thing that we would look at. Is there something in that arbitral procedure or in that, that litigation at its seat that could give rise to anything that could endanger that potentially favorable decision? The second thing that we look at, and I mentioned, the first aspect, because that's one of the ones that's usually forgotten, a bit too late in the day. The second one is, once we have an award, and that award has survived a challenge at its seat, the award always challenged. So once it has survived the challenge at its seat, where do we need to go? Can we go anywhere? Or do we need to be enforcing at the seat? And if we're enforcing at the seat, we need to have the tools and the means to fine assets, seize assets, freeze assets, whether it's at the seat or in other jurisdictions. And what would be interesting for me to find out in today's conversation is whether we're talking about set-aside proceedings in the BVI on arbitral awards, or whether we're talking about awards that were either rendered in the BVI or abroad, not necessarily in the BVI, but people are, the BVI being obviously a hub for corporate entities, whether there is anything stopping people from enforcing awards rendered elsewhere in the BVI. So that's certainly something that we look at first and foremost. I mean, one of the first things we do actually is we do asset searches on particular respondents and try to figure out in which jurisdiction we would need to do or start enforcement proceedings. And once we've seen which jurisdictions have interesting assets, then we will go look up to that jurisdiction's underlying rules, jurisprudence, to find out whether or not it's a jurisdiction that's going to be helpful or not helpful, depending whether we're also talking about a commercial entity or sometimes when we're talking about a sovereign entity. As you will know, there's sovereign immunity rules that come into play that make enforcement against a sovereign more difficult. Some jurisdictions tend to make it slightly easier, and some jurisdictions tend to make it slightly harder. I'd be keen to know what the position is in the BVI.
And what sort of degree, because so you've just explained the merits-based analysis, right? Can this award withstand scrutiny in either the seat or the jurisdiction in which it is sought to be enforced? But what degree of certainty would you need as a funder? Because you can never predict the outcome of any of it. Certainly from a litigation perspective, do you get counsel's opinion which says this has a 60 or 70% chance of success, or do you need an 80% chance of success? What degree of certainty that this won't be set aside would you need in order to fund?
Actually, for jurisdictions that are members, for instance, to the New York Convention, there is more certainty because the rules under which the award can be set aside, or the conditions under which the award can be set aside, are relatively limited. The one condition or the one route to setting aside that's relatively wide in all jurisdictions under the New York Convention is the public policy exception. And that's usually what we try to drill down on, is what does that country's public policy exception, what does it contain? For instance, in the context of sovereign arbitral proceedings, some countries have more or less wide views on what would constitute corruption. As we all know, corruption is actually extremely difficult to prove. And so depending on the various elements that would tend to not to prove, but to show that there may or may not have been corruption, some jurisdictions would put their foot down and saying, too many red flags here, we're setting this aside, the award aside. And some jurisdictions will say, no, this can't be proven, so I'm not going to set it aside. So in terms of level of certainty, we will rely on the existing jurisprudence. And we will rely on counsel's opinion if there is some lack of clarity. But that's something on which we don't take much risk, to be honest with you. The actual enforceability of the award is probably one of the most important aspects of our review of a case. The two most important aspects are the enforceability, and the other one is the quantum. Quantum is there really actually an amount of money at the end of the day, at the end of this proceeding, for the client and their funder and their lawyers if there's a success fee element. But we really do not take risk on those two very fundamental elements. So if there is a doubt as to the enforceability of a decision, or if there's a doubt as to whether we will find a route to enforcement down the road, then we're more likely to decline to invest in that opportunity.
Peter, Yasmin said she wanted to know in the Caribbean just how easy or difficult it is to enforce an award. Can you give us some insight on that and any recent case law on whether, I know the BVI is typically described as a pro-arbitration jurisdiction, but what exactly does that mean?
So in terms of the framework, the New York Convention has been extended to the BVI. BVI is also a member of the Washington Convention. So if you've got an ICSID award, there's a 1966 English Act, which is extended to the territory. So from a funder's point of view, the necessary framework is there. You're not in a scenario where it's non-convention. You're dealing with very familiar concepts. And typically they've adopted the English approach of looking at the public policy exceptions and construing those very narrowly. So there are things like terrorist financing, corruption, fraud. There can also usually be some sort of natural justice arguments where people say, I wasn't given a chance to present my case, or I think there's a Canadian judgment about not giving reasons for an award, which in Canada was set aside, and query whether that would happen here. But so there are the usual frameworks that you will have in any other New York Convention state. In terms of the case law, I would agree that it is a pro-arbitration. I mean, usually it is a straightforward application which is made under if it's a convention or even a non-convention award, to court. There have been a couple of cases. I think there was a case in 2017, a judgment of Adelise, which involved non-parties to an arbitration award, which can create difficulties. And in that situation, the judge said there has to be a full hearing of the merits of the case to establish why, under that particular foreign arbitration award, non-parties were said to be bound by the award. So there are sort of difficult scenarios. Sovereign states, again, that's another very difficult area. There's been a case recently, last year, TCC versus Pakistan, where the award was not enforced on the basis that, although there had been some form of adjudicative waiver of immunity, there hadn't been a waiver in relation to enforcement. And that is still a difficult scenario where we're having to grapple with those points of state immunity, which can give rise to very novel and difficult issues. So in terms of a funder coming to the BVI, I would say you're dealing with the usual parameters in relation to public policy. There are these outliers which will require further thought and consideration. Yes, in terms of enforcement, I think it's a fairly well-trodden path. The only other thing I think I would say in relation to enforcement is you will often find in the BVI, what happens is you bring your foreign arbitration award here, and you'll go straight to a winding up application, because as Yasmin said, this is a holding company jurisdiction. You don't have to get it registered. You can simply use that as the debt, and then you'll have a winding up application made. If you know where the assets are, if you're aware of where assets that the debtor has in BVI companies, often you'll have a provisional charge and order that's granted also immediately. So there are lots of tools which can assist enforcement for an award creditor.
And Yasmin, as a funder, well, certainly we typically are at the end of a third-party funding agreement, meaning we're presented with the agreement. In recent times, third-party funders have sought the assistance of some lawyer in the jurisdiction to draft in the actual agreement. Where you have, and maybe this is a question that Dana can answer as well, where you have a third-party funding agreement governed by one particular jurisdiction, the law of, say, for instance, England and Wales, and it's being considered in the BVI, its legality. Is that complexity something, and maybe I'll throw this to Dana, because I don't want, she's been quiet, I haven't been directing enough questions at her. Is that complexity or that conflict of law issue, or the potential for that conflict of law issue, how would you grapple with that in practical terms?
So I think from the funder's perspective, as Yasmin and others have mentioned, enforcement is a key aspect. And so you look to where the ultimate award may be enforced, as well as the seat of arbitration or the place where proceedings relating to the dispute may arise. And so, also there's often a relationship between the named parties in an arbitration and their affiliates or parents, and who may have an interest in the outcome of the arbitration, and they may be seated in a different jurisdiction. So from a funder's perspective, you would look at, for example, if there were a case in which a subsidiary were in an arbitration and the parent was incorporated in the BVI, and perhaps there were proceedings in the BVI or not, whether if that award were brought to the BVI, would it need to be produced to the courts? What does the jurisdiction of enforcement require, and how do you ensure that the funding of that arbitration is ultimately enforceable at the end, in whatever jurisdiction that may be? And sometimes that's not entirely clear. So you may have some idea of certain places where you would enforce against the respondent or respondents, or the family of respondents, but sometimes that jurisdiction changes, or you find assets in different places and you do a multi-front simultaneous effort to enforce, and you have to look at the legality in each of the areas. In that respect, it's less of a conflicts of laws as a multiple analysis of the laws in the enforcing jurisdictions. I think from an arbitrator's perspective, when arbitrators think of a duty to render an enforceable award, they're thinking more within the rubric of the applicable rules, the applicable law at the seat of arbitration, the governing law of the arbitration, and where, if it's obvious, where the award may be enforced. So, for example, if there were specific requirements with respect to an award, not necessarily relating to third-party funding, but if an award had to have a specific seal or be signed in blue ink as opposed to, a different form, or there were any kind of procedural requirements at the seat, or at a likely other jurisdiction of enforcement, counsel often will bring that to the attention of arbitrators because they similarly want an award that will be enforceable in the jurisdictions of choice thereafter. But that is something that an arbitrator would take into account. I think that's less related to third-party funding and more related to the award being a movable, enforceable award, across the world under the New York Convention or applicable convention.
So, Peter, can I ask you this? This is a scenario as an example. You have a enforcement of an award, third-party funded. You've been presented with the third-party funding agreement. It has, and we're seeking to enforce the award in the BVI. But the third-party funding agreement is governed by some other jurisdiction, the law of some other jurisdiction, say, for instance, Pakistan or England and Wales. If faced with this, a BVI court, faced with a third-party funding agreement governed by a different jurisdiction, how will the BVI court consider whether that funding agreement is legal? Will it consider the law governing the actual third-party funding agreement, or is it a public policy consideration that it doesn't matter what the law is, it's whether under BVI law this funding agreement is legal? Is there a departure from the standard conflicts of law rules where it comes to third-party funding agreements, considering that they're wrapped up so much in public policy considerations?
I think actually you have to go back a stage and you have to look at what happens at the arbitration stage. So if you have a position where under the law of the arbitration agreement, it is legal to have a funding agreement, and if there is a particular provision which allows for those third-party funders to recover their costs, and it is not illegal, there's no public policy issue in relation to it at the stage of the arbitration, then the question is, why would then that be raised at an enforcement stage? There was a case in 2016 in England, the SR Steel and Norscott decision, which essentially looked at when an award was sought to be set aside for serious irregularity because of funders' costs that had been awarded by the arbitrator. The way in which the court in England looked at it was to say, these fall within the definition of costs, other costs, which a tribunal is entitled to award. So the question, I think, if you have a foreign award and there is nothing that is per se wrong illegal or improper in relation to the funder, and there's nothing, in terms of if there's a costs award included in the award, then the BVI court, I think, will simply say, is this a New York Convention award? Does it fall within those parameters? So I don't think the court would necessarily have to go into the analysis. Now, so I think it depends on which stage you're looking at it, but I think that the main focus for the BVI court anyway would be, is this a New York Convention award? Is there anything which is abnormal about it? And if that award includes third-party funders' fees or success fee or uplifts or whatever it may be, and the arbitrators awarded them, then that simply becomes part of the award which you're looking to enforce.
Well, that's interesting. So it's not a standalone, separate sort of agreement per se, although it would be considered within the context of the arbitration generally.
That would be my view, yes. Yeah. Maybe wrong, but that's my view.
So we have a...
may I interject just for 1 second? Just to give the context of why we would look to that consideration. It's also because it has happened on very few occasions, but it has happened that clients have looked to challenge the underlying funding agreement. So take a situation where a client gets their arbitration funded. Imagine that arbitration is seated in the BVI. Imagine the funding agreement is under UK law. And once the award is rendered and it's favorable, the client is no longer happy with the commercial terms it has signed up to and seeks to challenge the underlying funding agreement. So in other words, not to pay the funder their share that they're owed from the recoveries of their arbitral proceedings. It's in that context that we would look to make sure that our funding agreement is bulletproof, so to speak, so that we are governing our funding agreement typically with the law of a jurisdiction we know has jurisprudence around funding, typically, for instance, England and Wales. And when we know that the jurisprudence has gone in a certain jurisdiction in a certain way, approving the fact of the general matrix of these funding agreements so that a client can't renege on their commercial deal. It's mostly in that context this has happened. It hasn't happened very often, to be honest. In my experience in the past 8 years, I've only seen it happen once, but it does happen, and that's one of the reasons why the governing law of the funding agreement and the way it would protect the commercial deal is important. And what we've seen is that courts will vary in various jurisdictions, and even non-common law ones will very readily look to the jurisdiction. I mean, a conflict of law, as you said, Tameka, general rule, which is apply the law of the contract that the parties have decided to apply to their contract. And when looking towards a jurisdiction like England and Wales, then it's much easier for the judge to uphold a funding agreement in that way.
So that's
sorry,
a
that
risk.
was the context.
No, that's a different and good point. It's not just the funding agreement itself, but the client seeking to essentially undo the bargain that they struck now that they've won and they've had a change of heart. So that's a risk, I think, for this funder. Another, and this is going to segue into one of the considerations that who was joining us virtually, I think Chris Hamill-Smith, has asked us to consider, and I think this is actually for you again, Peter, sorry, but Dana, Yasmin, you can jump in if you can add additional insight. So typically for us in the Eastern Caribbean, one of the intersections of third-party funding that arises is in the context of adverse costs awards, where, for instance, in a matter that's third-party funding, how do we manage that? What's the current rule where there is an adverse cost award is against a third-party funder? For instance, who pays those costs? Can the victor or the winner seek its cost directly as against the third-party funder?
So again, I think we have to make a distinction between litigation and arbitration. So if we're looking at arbitration, in terms of, for example, security for cost applications and things, there is a power on the in the arbitration, the BVI Arbitration Act, to enable the tribunal to ask for a claimant, but the claimant is defined obviously as the claimant, not as a third party. Mm-hmm. Sometimes in the funding agreements there will be indemnity provisions which are included. So if any order which is made against the claimant, for example, put up a provision for security for costs, there will be a request made to the funder to say you've agreed to indemnify me for this particular risk. So that there isn't in the BVI arbitration either AIC rules or the Arbitration Act's provisions in relation to how to deal with those sort of third-party applications, but typically they'll be dealt with within the funding agreement that's entered into. If you're in court territory, so suppose you're in an enforcement scenario, you've gone to court, you want to get your awards enforced, and there is a third party. Now again, you can either a third-party funder, you will either have a provision in relation to an indemnity within the funding agreement. So any order made against the award creditor in relation to costs there'll be an indemnity provision, or there is a third-party cost provision. I mean, so it is undoubtedly the case that there is potentially, risk for a third-party funder to say, you have to be liable for costs on this. But we tend to follow the English approach in relation to that. There'll have to be a separate application made against a third party. They'll have to, come to the jurisdiction, etc. But typically, in my experience, it's been dealt with within the funding agreement regime, so you haven't had to get into issues of third-party cost orders.
So Yasmin, you would mitigate that risk ahead of time, right, in the funding agreement itself?
Yes, definitely. We would first of all get more information as to how a jurisdiction deals with these orders, and to what extent a third party could be held liable for adverse costs. But very, very generally, in common law jurisdictions that have a cost follow the event type rule, we will almost automatically put in place after the event insurance to cover any risk of adverse costs, either towards the client or, worst case scenario, towards the funder themselves. That's typically the kind of risk that we wouldn't take, that we wouldn't leave uncovered from the outset. It's unnecessary. It's an unnecessary hardship for parties and for the funders to find themselves in that position. There is now a very sophisticated and quite large industry of insurance around litigations and arbitrations. Funders are particularly well equipped to tap into the various insurance products in order to prevent themselves from being held liable or for their clients to be held liable. So we would definitely put in place that kind of mechanism.
Dana?
Well, that's largely the point that I was going to make, that typically the funding agreement speaks to this or doesn't speak to this because there is an insurance component that covers this risk. So from a funder's perspective, I think that they do always anticipate this potential risk, even if the likelihood of success is assessed as quite high. And the insurance market, as Yasmin said, is very, very sophisticated and offers a number of different avenues in terms of protecting against that risk of if the case either when there's a security for costs award or costs follow the event. And I think still, while there's many applications for security for costs made in the context of arbitrations where there is a funder behind the claimant, very few are granted, and the factors for granting an application for security for costs are not so closely linked, if linked at all, to the funder. It's much more about the claimant and the claimant's history, track record of paying its obligations. But as has been mentioned, this is obviously an area that could be of risk to a funder, and therefore a funder typically takes this into account and provides for it either in the funding agreement or through insurance, or you know, a mechanism that uses both in the different situations as it may arise.
But I have a sort of a comeback from an attendee, Calvin Hamilton, and he said this all presupposes that the funding agreement is disclosed. That then raises an interesting question as to the disclosure of funding, third-party funding agreements. And I had raised this earlier with you, Dana, but it would be useful to get some insight, certainly from you, Peter. Is there and we can deal with this both in the context of arbitration and in the context of the enforcement of an arbitral award in court proceedings. Is there a obligation to disclose third-party funding agreements? I know that Dana sort of answered it in the context of the arbitrators asking the question at the outset for the purposes of establishing whether there is a conflict. But quite apart from that, is there, under BVI law in the Caribbean or a course of conduct common law, is there an obligation to disclose the existence of a third-party funding agreement?
For me, yeah.
Yes, that's okay.
Yeah. Is there an obligation? Well, I think in terms of what disclosure you need to give, if it is something that is relevant to an issue in the arbitration, then a party would be entitled to say, I want disclosure on it. It depends on the context in which it's arisen, because you can have scenarios where, because there is a funder, it may affect the way in which the strategy pans out in terms of settlement, in terms of approach. But are they entitled to see the funding agreement? I think it will depend if it's relevant to an issue. If it's not relevant, then there wouldn't normally be an obligation. It depends on what the rules are as well of the arbitration proceedings. As Yasmin said, there is consultations going on in relation to making it an obligation to disclose. But at the moment, under BVI, either the IAC rules or under the Act, there is no specific obligation unless it goes to an issue in the proceedings. And so it depends on how the application would be constructed.
And frequently you find that parties don't know that there is the other side of it would not know that there's a third party funding agreement, and therefore would not know to ask the question to have it disclosed. So I certainly know that in the context of litigation, there isn't an obligation to disclose a third party funding agreement unless it is issuing the claim. But there has been some debate.
Often in the context of court applications here, because the funding arrangements have arisen in the context of an insolvent company, everyone knows that somebody is funding because the company's insolvent. So although it's never been, you know, it's as you're right, as you say, there may be no obligation to disclose, but it's an open secret that somebody is funding this particular litigation because but
for enforcement, because we have for enforcement, where you're enforcing an award and that is funded, the respondent to that would not know that it's funded at all. So they won't know to ask for disclosure of the funding agreement because they don't know there is a third party funding agreement. Dana, you had unmuted your mic. I think you wanted to say something.
I was just going to say that, I mean, I think it's rare that the funding agreement itself is produced in the arbitration. It's a different issue with respect to enforcement of an award and what the jurisdiction requires, and specifically to Peter's point, if you're dealing with an insolvency proceeding, it may be that, and again, I'm speaking in generalities, I can't speak to the law of the BVI, but I think that there are circumstances in which the funding agreement may be viewed in camera and not necessarily, you know, produced in the American vernacular to the parties or to the counsel in the arbitration. But I think that would have to be prompted by either something specific in the legislation or the law at the seat at which the award was sought to be enforced in the context of an insolvency proceeding, and that the judges are quite sophisticated in anticipating these kinds of issues and kind of know what to ask for, what they need to be able to handle the specific issues of that.
Yasmin, have you been on the other end of a sort of as a funder of an application to have a third-party funding agreement disclosed?
Many times. We have been more often than not involved in arbitrations when the fact of funding was disclosed at the outset. And therefore, usually that gives rise to quasi-automatic requests for security for cost, especially in the context of investment-free arbitration, which we do quite a fair bit of. So, and almost systematically, there's a request for disclosure for the actual agreement. The reasons given is because they want to see whether, for instance, there's AT insurance in place, what happens in the context of adverse costs, whether the case is fully funded, or whether we're going to be forcing the respondent to defend themselves and then suddenly have to drop the claim because it's not fully funded. So respondents have come up with a number of reasons for seeking to request the agreement. Very validly, obviously, I'm biased, but I think that 99.9% of the tribunals out there have refused to order the disclosure of the funding agreements. When they have, they've ordered the disclosure of very redacted parts, really relating to the ATE part, the insurance part, the adverse cost part of the agreement. And the reasons given by the tribunal are quite clearly that it would be a really unfair advantage to be given to the respondent to understand the full financial matrix of the financing of a case in that context, and therefore and the reasons given for the need to see it were just really not really valid at all. And this was also, I think, in a couple of cases seen as a further tactic used by the respondent. I mean, remember that in the context of these cases that I'm talking about, these investment treaty cases, we're often in a context where a state has either pretty visibly expropriated or nationalized an investor, usually with some form of military guns, machine guns, investors going to prison. So people that have been mistreated already personally, also financially, then find themselves in a position where they've lost everything and don't have that kind of access to justice because they have nothing left, need to resort to funding in order to actually get their day in court. And then the respondent keeps on saying, well, wait, let's do bifurcation, wait, security for cost application, wait, I'm going to challenge the arbitrator. And so this usually comes in a context where arbitrators are already tired of the guerrilla tactics used by the respondents. And so far, so good, I would say, for most claimants. Tribunals have turned that down because there was no valid reason to see the actual agreement. But I think one point that needs to be made is that from a funder's perspective, funders are perfectly happy for the fact of funding to be disclosed and for their identities to be disclosed. Because if you think about it, this is an actual additional layer of security for the funder that the arbitration, which is our investment, remains whole, that it can't be challenged later on for a conflict of interest or perception of a conflict of interest that we may not have been able, we may not have been able to raise earlier. So the disclosure is actually of no issue to funders. Sometimes clients don't want to disclose the fact of funding. And there are many reasons for which clients don't want to disclose the fact of funding. Sometimes clients will tell us it's nobody's business how we're financing this claim. Whether we're getting a bank loan, whether we're getting our shareholders to put more money in the pot, whether we're getting a third party to put in money, it's actually nobody's business. And that's something with which we can't argue. So if there is no obligation in the actual rules, whether local jurisdiction or arbitration was to disclose, we can't force the client to disclose. It's their call, it's their arbitration.
Thanks, Yasmin. I have two other audience questions, and I will just throw it out to the panelists and sort of each can answer that. There is a question about and maybe Dana, this might be more appropriate for you. What about a general obligation to disclose funding arrangements so as to avoid potential conflicts between arbitrators and funders? Arbitrators can only make disclosures if they know of the funding arrangements. So is there a general obligation to disclose funding arrangements so as to avoid potential conflicts between arbitrators and funders?
I think that's a good question. And I think that rather than an obligation, because there's not an across the board obligation in all jurisdictions or under all arbitral rules or court rules to disclose funding arrangements. But I think that as Yasmin referred, like, I think the practical reality is that the trend is that disclosure is favored and elicited by either the tribunal or the party because they want to avoid any risk of conflict and a reason for the award to face baseless challenges later or not baseless challenges. I've never seen the disclosure of the fact of funding and the identity of the funding actually give rise to a conflict in my time as a funder or as an arbitrator. But conceptually, it is a possibility. And it is for that reason that I think that the trend is to disclose the funder, the identity of the funder, less so the nature of the funding, because that doesn't go to conflicts. Also, often when the funder is disclosed, to the extent that there is ATE insurance or an undertaking, or sometimes a funder will file a deed poll and just say, take the issue of security for cost application off the table, that's covered. And so just only address it on the merits with respect to the claimant or the party for whom there might be a concern, but the insurance is there. It's not a matter of a funder not stepping up. But I think that generally it's not as much an obligation as a trend. It's moving, I think, closer towards an obligation so as to avoid the concerns that we've described, especially in the enforcement stage. But again, I've yet to see a funder have a conflict based on the disclosure of funding. But maybe that's also why funders are so, I don't want to speak for funders generally, but there seems to be, a lack of concern to disclose the fact of funding and the identity of funding because it makes for a more enforceable award, and that aspect is not really the confidential aspect. It's what is the financial terms, and that's really doesn't go to the merits of any arbitration, the dispute between the parties in the arbitration. That's a totally separate issue.
Peter, can I ask you, as a matter of BVI law or the rest of the Caribbean, do you see that as presenting a potential ground for setting aside an award, the fact that a third-party funding agreement had not been disclosed during the course of the arbitration? Even conceptually, would that, in your view, form one of the grounds for setting aside an award?
No, because you end up having such a narrow ground of the exceptions in terms of public policy. If funding is legal, and it's legal in the jurisdiction where the award has been obtained, and the arbitrators have made decisions on the back of it and awarded costs and uplifts and various things in relation to it, I can't see how a BVI court is then going to say that's reason not to enforce the award.
So I have we have 7 minutes left, and I think that's enough time to deal with which question or topic, which I think is actually very important, which is managing the challenges associated with the potential misalignment of interests between the party and the funder, particularly with respect to settlement-related decisions. So, Yasmin, the party and the funders don't see eye to eye at some stage. How do you manage that? And generally, and in the context of settlement discussions?
Of course, very important issue. The way we tend to manage that, and I think that's the way any sophisticated professional funder would handle that, is to have very honest, open conversations from the outset with the client. It's very important for us to understand and for the client to be upfront with us as to what their needs and wants and expectations are out of their procedure, and for us to do the same thing with the client. It's the only way that you can deal with this particular issue of potential misalignment is if either party is not upfront. So if a funder is looking for a particular return, minimal return, then the funder needs to put that in the funding agreement. You will have noticed that all funding agreements usually calculate the funder's return as either a multiple of the money invested, which tends to be the floor, or a percentage of the damages recovered, which tends to be the ceiling of the funder's return. Similarly, if a client is looking for something else other than money in an arbitration, say another long-term contract with the counterparty, some different, perhaps non-immediately monetary solution, client needs to be very upfront with us, with the funder about that. And then we would look for other solutions in order to build that into the funding agreement so that a funder could be paid their return, maybe on a longer term than just a lump sum cash payment, but to see whether we can build that into the arrangement. If, say, a client is running their arbitration only for the sake of wanting to win, and they're not particularly looking for monetary compensation or some form of long-term contract thereafter, then that case is not appropriate for funding and they should not be seeking funding for it. Because let me be very clear, if this has escaped anybody, a funder is looking to make a return on their investment. There is no other underhanded interest that a funder has in an arbitration. It's not looking to create conflicts of interest. It's not looking to evade adverse costs. It's not looking to do anything underhanded. It's just looking to make a return on its investment, having covered all of the risks that it can foresee at the outset. One of those risks is potentially the misalignment of interest of the client. So we tend to vet our clients in the same way that we vet the actual dispute to make sure that when they say that they're looking for a particular form of resolution, that's exactly what they're looking for. So what we've done in certain contracts, for instance, is either we've said, well, this is the return the funder is expecting. If there's not a monetary resolution to the dispute, and if, for instance, the resolution is in the form of a commercial deal, this is how we would calculate the return to be paid to the funder over the next 5 or 6 years, whatever would be appropriate for that case. Another thing that we can put in a contract is set thresholds the parties agree on in terms of settlement. And say, for instance, in most common law jurisdictions, a funder can't have a say per se in the settlement, but they can agree with the client that on the basis of the money they're investing and the damages that are expected, what are the different thresholds of settlement that the parties can agree on? They can say, for instance, below a certain number, a client will need to consult with the funder before agreeing. But truth be told, once you've had that conversation and you've put in all those caveats in a contract, many things can still happen. And when it really comes down to it, and imagining that you're in the context of an ongoing arbitration and there is a settlement offer on the table, and I can say this very confidently for any sane funder out in the market, if there is a serious settlement offer on the table, a funder will always assist their client in order to strike a deal. Even if that means sometimes modifying the deal that they had originally agreed to, because money today that's certain in the bank is far more valuable to everybody, including the funder, than maybe tomorrow. With the caveat of, are we going to win? Are we going to be able to enforce? How much money are we going to have to invest more in order to enforce? So this issue of misalignment in reality is not something we've experienced per se, because A, we deal with it at the outset. We understand, we make sure that our expectations and the client's expectations are very clear. And 2, if and when settlement conversations are on the table, we're on the client side. We're looking for the dispute to settle. We're not looking to drag on a dispute for longer to make for an internal rate of return that's slightly higher. If it's already such a high risk game. I don't know if you realize this, but funding is already such a high risk element, because there are so many things that can go wrong in an arbitration or litigation up until the hearing and after the hearing. When there is a real opportunity to settle the dispute and to move on, a funder will usually assist the client to do that.
Yes, and I think a litigator would settle as well if, because of the uncertainty, high stakes game. There's one final question. I think we have time. And Peter, this question is possibly more for you. And the question is whether the existence of a third-party funding agreement will increase the chances of a security for cost order being made against a claimant or the person that's being funded. I know from a BVI law perspective, the fact that a claimant is third-party funded is one of the considerations in an application for security for costs. But in the context of arbitration, would the existence of the third-party funding agreement, and I know Dana touched on this a little bit, but not specifically with an answer, would the existence of a third-party funding agreement increase the chances of a security for cost order being made against the person being funded?
I think firstly, if you've got to look at the power, what power is there under the terms of either the BVI IAC rules or under the Arbitration Act to grant security for costs. Section 54 of the BVI Arbitration Act only refers to claimant as opposed to sort of third parties having to put up. So query, is it a relevant factor? And the fact there may be a nominal claimant, which I think is what you're referring to under the CPR, hasn't been reflected in the Arbitration Act, so it's got a slightly different wording. The IAC rules are entirely silent in relation to security for costs. They refer to interim measures, and so it may be that that's an interim measure, which is what some other institutions adopt. But it's such a rare occasion, as Dana said, for security for costs to be awarded in any event. So I think probably it is a factor, but I don't think the existence would increase the possibility to a great extent.
Dana, do you want to answer that as well? I know you've sort of answered it already, but it may be useful for the audience.
I agree with Peter. I think that, and Yasmin also mentioned that in certain contexts, especially in the treaty arbitration context, when there's disclosure of the fact of funding, it's almost robotic that you're going to get an application for security for costs. They are very rarely granted, and in general, there's not a lot of focus on the funding aspect. It's much more of a focus on the claimant and the claimant's payment practices in the past, and are there any awards in the past that the claimant has not honored, and sort of what the practices of the claimant have been, and less on the funder.
So before we end this session, I just wanted to ask a final question, for which I would kindly ask that each panelist answer, which is, what's your perspective on the future of third-party funding? Yasmin, you can start.
I think there's many ways to answer that question, Tameka, but I think perhaps the more relevant one for this conversation is to say that the actors in the funding world have evolved significantly in the past 15 years. We've seen the form that funding takes also evolve greatly. So we've gone from the David versus Goliath type funding towards this large corporate portfolio funding. So, not just single case, but funding of portfolios, funding of law firms. So funding the actual risk that law firms take on cases. And truth be told, the lawyers that work for funders started off as arbitration specialists. And well, I work in a financial industry now, and that's really what I do. The underlying asset of what we do is law, obviously, and that's still very important. So there has been a financialization. I don't know if it's a word. It probably isn't. It's going to be one, I guess.
It's a new word now.
Newer now. Of the legal asset and funding around that legal asset that is getting very, very, very sophisticated. And I have to say, and that's not just because Dana is from New York, but New York has been actually very interesting and important in that evolution, because initially there weren't many funders in the US. The funders really started off in Australia and then suddenly mushroomed in the UK and around Europe. And the past 8-9 years started, blossoming in the US. And especially in New York. And as we know, New York is truly the financial center of the world. And so these litigators, arbitrators, financial specialists started drawing from many other aspects of private equity, trading markets, and so forth, and have imported all of those things into ways in which funding can be structured. Because I think one of the most important things that I would like to leave the audience with is that there's not one size fits all in funding, in legal assets and in legal finance. And every case tends to have quite different structures of funding and perhaps calculations of returns. I mean, I have to say, I have to give you one example. I saw a case, we hadn't done it, but it's a case another funder did, an American one actually, where they had structured their return on investment on the trading price of bananas, and exactly in a context where there wasn't a lump sum to be paid. And they use that tool, that trading tool, in order for the funder to be paid their return on investment and everybody to go home happy. So I think the evolution of funding is definitely going to go more and more towards importing all these different tools from other financial industries and using them for the clients as, you know, as what it is, a purely financial tool. And we will continue to see funding to continue evolving in different jurisdictions, and will continue to start evolving as, you know, as a David versus Goliath, and then move on to more traditional single case, and then move on to the corporate. So it's going to be, I think, a repeating cycle over and over again as the industry develops. And one of the things that we are already seeing is that there's funding of funding, and so there is structured financing around funding. Funders that are now selling portions or slices of their portfolio. We're still very, very far from any risk of subprime, if that's what some people are thinking, because the underlying due diligence on the individual cases is still quite insignificant, because the individual assets are still very onerous. The subprimes, what happened is that it was individual loans of $5,000 or $10,000, and that's why the due diligence process got lost in the mix. Here we're talking about very onerous assets. We're still talking about arbitrations for, at a minimum, $5 million of investment and $50 million of damages. So it's very interesting to be part of the industry and to be seeing this evolution, and to see the entrance of these other financial actors. I mean, we were acquired 2 years ago by Fortress Investment Group, which is a large American hedge fund. So we've gone from being a $250 million English family office run funder to, you know, being a $50 billion American hedge fund that invests approximately $6 billion in legal assets. And so it's evolving very quickly.
Dana?
Well, I agree with what Yasmin has said, and this is a quickly changing landscape when it comes to third-party funding, both in the way that the funding agreements are structured. They definitely are picking up some of the innovations from the finance industry that had not been used, say 5 years ago, 10 years ago. Now, you know, most funders are much more creative and open to different ways of structuring things. And I think that that's also encouraged or facilitated in part by the increasing legality of funding in different parts of the world that had traditionally been closed to funding or very narrow in terms of what it permitted in terms of funding. Now, as the world is recognizing that funding is a tool used by parties in arbitrations and litigations around the world, and are starting to be more receptive or pass legislation expressly acknowledging the legality of funding, that encourages people to focus on what is funding and how is it structured, or how can it be structured, or how can it be maximized. The engagement of the insurance industry with the funders and you know, working together to come up with different kinds of financing vehicles, portfolio funding. I mean, the whole area has really become far more sophisticated and blossomed. And I think in part it's because of the need for funding has been recognized, and there's there's less, quote, shame in using funding. People use funding as a financial tool, not because they're impecunious, but impecunious claimants use it too. But also because it's becoming more and more permissible, so it gets discussed more, and courts have more exposure to it and have addressed it. And there's clearer rules of the road for parties and funders, and enforcing courts as well.
Peter, from the lens of a Caribbean practitioner, where do you see third-party funding?
Well, picking up on Dana's road analogy, I think the direction of travel is only going one way here. So I think the legal infrastructure to allow third-party funding is definitely going to be upon us. Came and brought in the Act this year. I know that there is a proposal that's currently before the legislature here for a similar type of proposal. Two comments really, just in terms of practicalities and the challenges going forward, certainly for this jurisdiction. I think one is that the amount of investment that either the client, who may be impecunious, or more often the law firm, have to do in order to get a case off the ground. So in order to take the case to a funder, there's going to have to be a lot of investment, usually by the law firm, of hundreds of thousands, which could be sort of lost income, and then how that is dealt with. I mean, sometimes some funders will say they will reimburse for legal fees, but equally funders don't want to sort of be presented with a bill for $1 billion and say, we've got this great case for you, please pay our last year's WHIP. So the issue of how you get to that stage of, you know, getting the case to the funder is a challenge, I think, for lawyers. And the second thing, which is specific, I think, for this jurisdiction, is while we have lots of cases that are a significant value, there is a whole series of cases sort of sub 20 million, which is quite difficult in the current state of the funding markets to find funding for, because it's simply the values are too low. So presumably it may be that there, you know, that segment of the market will develop, but those are two challenges I see in the future.
Well, Yasmin, Dana, Peter, thank you all so much for your time. I think this has been, we can easily go on for another half an hour to an hour, but I think we've overstayed our welcome at the BVI IAC. And thank you to the audience for joining in. Thank you to those who asked such questions, which were all very good and allowed us to unpack this topic in a multidimensional way. So thank you very much for that participation. And thank you all for dialing in, and enjoy the rest of the day's sessions. Thank you.
Thanks, Tameka. Thanks, everybody. Bye-bye.
Thank you, Tameka. Thank you, everyone.
Thank you. Thank you, guys. Bye.